Welcome, everyone, this huge crowd of people that came. Just kidding. I am Corinne Yantz. I'm with CVOEO's Fair Housing Project. That's Champlain Valley of the Economic Opportunity. And we are part of the Housing Advocacy Program. I am joined by my colleague who's actually named Ash, not Kara Names. Sorry about that. But Ash is in the audience for today. Don't know why I'm introducing you at this point. But the Fair Housing Project and Vermont Tenants works really closely together. So we'll be kind of circling back to the Vermont Tenants program and the hotline quite a bit throughout this presentation. And just to kind of set the stage of what we do, so the Housing Advocacy Program, we're a statewide program in Vermont. We include the mobile home program. So our mobile home program works with mobile home residents across the state. We have Vermont Tenants, which includes our tenant hotline, which I just mentioned. That's a resource for renters to call if they have questions, any kind of tenant-related questions. So about your lease, landlord entry, what your rights are, habitability issues. These are all things that we can answer on our hotline and more. And then, of course, as I mentioned, I'm part of the Fair Housing Project. And so I'll be talking about what fair housing is, what the Fair Housing Act is, but kind of more broadly, what a big part of what I do as a fair housing advocate is talk to people about housing inclusion in the state. And that can be through the Fair Housing Act and understanding housing discrimination, and it can also be through thinking about our housing policies and how they impact our communities. So as I mentioned, the Vermont Tenants Hotline. This is a really important, incredible, and underutilized resource. Although I will say we're getting quite a few calls right now. Not to dissuade you, you should call if you have any questions about your lease. So it's 802-864-0099. Again, that's our Vermont Tenants Hotline. And basically how it works is you call the hotline. Most likely you're going to leave a message. Madeline and our other hotline advocates are often on the phone with other folks and taking a lot of notes, and but they will get back to you. So you leave your message, let our hotline advocates know how to get back a hold of you, maybe give them an idea of what your question is. If you prefer, you're welcome to contact our email instead, so that's vttenants at cvoeo.org. And this is just something I'm going to keep referring back to throughout this workshop, and I always refer back to, because in the end, our housing problems can be really complex and very personal, and can have complex needs, complex laws that they're interacting with. Yeah, we just want to let people know that there's a person that you can talk to on the phone. And then other things Vermont Tenants does is, of course, workshops like this. We do a lot of referrals, so Vermont Tenants will often connect people to appropriate resources if they're not the person that can help them. And we all do housing advocacy. It's in the name of our program, Housing Advocacy Program. So what we're covering in this workshop today, we are teaching people how to identify legal protections under fair housing law. Again, I'll be talking more about what that looks like. How to recognize if you've experienced illegal discrimination in your housing search or residence. We're not going to be talking about best practices for housing providers, because this is a workshop for tenants. Actually, I take that back. We will talk about that so that you can know what the best practices are for your housing providers as well. And then how to seek help if you face housing discrimination. I will also be talking about how to communicate effectively with your landlord about your rights and responsibilities, and how to utilize resources and best practices to ensure your privacy and you get your security deposit back, and more. I kept this kind of amazing and very daunting slide because I know some folks watching this might be a person utilizing subsidized housing or advocating for subsidized housing. When I say subsidized housing, I mean housing where you have a subsidy, like voucher, or you're part of a program that allows you to pay no more than 30% of your income on rent, or otherwise makes your housing more affordable. And so what we're looking at is all the different ways we fund affordable housing. And so this is just to say that if you're a person that's living, for instance, at you know, a nonprofit affordable housing site, or perhaps living in a housing authority rental property, there's a lot of kind of legal protections that you have, and also there's this kind of overlapping of requirements that each agency has because of how complex their funding source is. So basically we're looking at, this is how we fund our housing. Most of our affordable housing has really like big funding sources, and therefore they're following a lot of different rules too. And this is just to say it's complicated, period. We start with fair housing, which is not just a part of tenants' rights, but also rights for home buyers and anyone living in a home. And so fair housing is, what do we talk about when we say fair housing? Oftentimes when I go into a community, I say, I'm going to teach you about fair housing. The first thing I hear back is, I'll tell you what fair is. And when we say fair housing here in housing, we're referring explicitly to or specifically to the Fair Housing Act. So that is a law all across the country that that is intended to protect people from housing discrimination, with the mission to increase housing choice for everyone, which I can say with confidence, not everyone has housing choice. So it's not quite doing what it's intended to, but it's really important for people to understand what their rights are under fair housing so they can know what they can ask for and advocate for themselves. So when we say fair housing, we're talking about Fair Housing Act. That might mean that something can happen that feels unfair. It might be unfair, but it might not be housing discrimination. And I'll tell you a little bit more about why. So as I said, it's a federal law. All across the US, we have the Fair Housing Act. And what the Fair Housing Act does is it looks at groups of people that face the highest barriers to housing. So Fair Housing Act, it came into place to protect people of color, so people based on the color of their skin. It's called the protected class. That's the language that we use when we're talking about the Fair Housing Act. It was an act passed in the wake of the assassination of Martin Luther King, and was specifically responding to the incredible rates of discrimination Black and brown people were facing in the US. That said, Fair Housing Act has increased. We've looked at other groups of people that were facing high rates of discrimination and not accessing the housing they need. So all across the country, we have these 7 protected classes. I'm going to go through each of them. I'm going to start with the disability protected class and just say that actually, under the Fair Housing Act, the disability protected class has actually some additional rights afforded that we'll be going into detail about, and that's, I'll get into that in a minute. Of course, race and color are both protected classes. That's why the Fair Housing Act came into being. Sex, so recent, should say that with like the HUD is the administration that oversees a lot of how we understand housing policy. And right now we're understanding sex to mean also gender. So that means that a landlord can't discriminate based off of sex and gender of any kind. Color I already mentioned, country of national origin. So that would include, for instance, if a landlord was to say, I can only rent to people who speak English. That is that's discrimination based off of country of national origin. And there's actually a lot of more nuanced ways that discrimination does happen based off of country of national origin. For instance, I've heard of a recent case here in Vermont where a tenant was being harassed because of the smell of the food that they were making. So just to say that there's some pretty explicit ways that housing discrimination can happen, and then there can be pretty nuanced and hard to decipher, like what the heart of the problem, like what the heart of the policy is, and whether or not it's specifically a fair housing violation. And we're here to talk to you about that. That's always the case when we're going through these really complex laws. We're here to go through that with you. Religion is protected under Fair Housing Act, and then family status. So when we say family status, we're often referring to families with children under the age of 18. So it is not uncommon to hear landlords violating the Fair Housing Act by having certain rules and restrictions targeted at families with children. And I'll be talking, of course, about what you can do when you experience those instances of discrimination. So those are the national protected classes. Each state has the opportunity to expand on expand on fair housing protected classes. And again, I know the lingo is like pretty like jargony, and it's just like what's in the law, so it's what we have to use. So not all states do expand on the Fair Housing Act. Some states are like, that's fine, we leave it as it is. And you know, I have some critiques of that, but here in Vermont, we have expanded the Fair Housing Act. And one of the really important protected classes I want to highlight is receipt of public assistance. So that means that in Vermont, and I'm realizing as I'm doing this workshop that some people might be watching this from New Hampshire. So if you are in New Hampshire, you have a different set of protected classes. I should have just, yeah, so, but the national ones are certainly still true. In Vermont, it's illegal to discriminate based off of receipt of public assistance. So that includes the housing choice voucher, formerly known as Section 8. So that's a really important voucher that some people use to, it's called the housing choice voucher because you can use it with any landlord. And in Vermont, it's illegal to say no. You can't, it's illegal to say I don't take Section 8 as a landlord in Vermont. At this point in the workshop, I often get a big ah, like from the audience because people experience it all the time. And part of that's because people don't understand that it's their right to have access to that housing because the education piece is just so limited. And oftentimes, it's not uncommon for me to come across landlords that actually don't even know that they're violating the Fair Housing Act by denying Section 8. You know, I still personally have some, you know, critiques of that anyways, but all to say that receipt of public assistance, the other kind of receipts of public assistance that people might have, you know, people who have like subsidies for their food, people whose income might be SSI, any kind of subsidy that you need to live your life as a person, a landlord can't deny you based off of that. That said, a landlord can and does often deny people if it looks like their income, like all of their income, isn't gonna be able to cover the rent. So that is something that can legally happen here in Vermont. Gender identity and sexual orientation, Vermont has that as a protected class, although at this point in time, we are also recognizing the national protected class as including that. Marital status, so a landlord can't say like, are you two married if you're like looking at an apartment, or like I only rent to married couples, or even kind of there's like ways that like people can kind of start touching on that where again it gets complicated and we can work like couples only, like sometimes can be a marital status discrimination, piece of discrimination, and those are conversations we can have with you. And a lot of times what it comes down to is like what the lawyers can advocate for. Age is a protected class. So up in my neck of the woods, I live in Chittenden County, and there's a lot of students that go to UVM that rent in my neighborhood. And so some landlords will say, actually, I only rent to student-aged people, or they might say students only, but like you can see from who they're turning away, it's a specific age bracket, and that is a violation of the Fair Housing Act. And then a really kind of loaded protected class that I'm going to quickly summarize and say that it's again complicated and personal, and it's something that you should certainly talk to us about if it's something that you need help navigated, is that most recently Vermont added victims of abuse, sexual assault, and stalking as a protected class. Again, this is the language in the law. My background in that field would have said abuse, survivors of abuse, but the law says victims, so I just want to make that clear that oftentimes I'm kind of like constrained by what the law says. But this is to say that if you're a person that's in this like really precarious situation where maybe someone is coming to your place that you used to have a romantic relationship with, and they are they're disrupting the peace. They're yelling or they're loud, and maybe your neighbors are calling the cops a lot, and your landlord says, hey, like these cops can't keep coming. Like I'm gonna end your tenancy. That's where this protected class comes in, because you have protections in that moment. That's something that we can help advocate for you. And the other thing I'll be talking about too is just the whole eviction process, because oftentimes when people get that first eviction notice, their instinct is to get out because it feels scary. And it is a process that you should be familiar with, and we'll be talking about and covering as part of this workshop. All right, so fair housing. It is loaded, it is complicated, it is like, I'm not a lawyer, and I'm just trying to interpret the law. Always, that's another thing we have to make really clear. We're not lawyers, we're educators, and so when it comes down to like the hard answers when it comes to fair housing, we always connect you to the appropriate resource, by which I mean someone who's a lawyer. But just to say, so Fair Housing Act. So obviously, based on being part of these protected classes, so a landlord can't refuse to rent to you. So I made the example with like children. So if you have kids, let's say you go up to an apartment and you have been on the phone with a landlord, and all of a sudden you get out of your car and your kid's with you, and your landlord is like, whoa, you didn't mention you had a kid, I don't rent to kids. Obvious discrimination, that's just cut and dry. But there's, again, a lot more nuance. So something that we actually do hear a lot more of is, for instance, all right, so you get your lease with your kid, and you notice that your lease has quiet hours. You're like, huh, that's weird, we never talked about that. You talk to your other neighbors that don't have kids, and they don't have quiet hours in their lease. That is a violation of Fair Housing Act. And that actually does come up quite a bit, because landlords don't have to take a class. So they, it's their property, they set the rules, but they might not know that they can't just add clauses to leases based off of someone's protected class, and based on their own assumptions about what it might mean to have children living in the building, for instance. Another really, in fact, very important part of the Fair Housing Act. All right, so Fair Housing Act, purpose, give everyone housing choice. People should all have housing choice. Again, I said that's not true yet. I hope one day it will be. For that reason, it is illegal against the Fair Housing Act to do what's called steering. So steering is when a landlord redirects you to a different building. So let's keep going with the kid example. So you get out, your kid gets out, and your landlord's like, oh, I didn't know you had a kid. And then it's like, actually, you know what? This apartment is not a good fit for you, but this other apartment is like closer to the playground or closer to the school. You know, even if they're like trying to do you a favor or telling you that they're doing a favor, that moment is still steering. So the landlord's legally obligated to show you both the unit that you came to see and this other unit that they wanted to steer you to. And it's just, I can't tell you how many landlords I've had conversations with who are like, well, if someone comes to my unit and I see that they're in a wheelchair and I know my unit's not navigated, like they can't navigate it in a wheelchair, I want to show them this other unit that will be easier. That person, if they've got a wheelchair, that's how they live their life. They know how to get around the world. They can make that decision on their own. It's not for us to make. And that's why it's really important that even if you think you're doing, you can let them know, like, hey, I'll show you this apartment and I will show you this other apartment that might meet your needs. But it's not for you to anticipate the needs of a tenant. And I'm saying you, even though it's a tenant class, but just to say, like, it's not for the landlord to decide. It's the tenant's choice. And that's another place where it can get like really nuanced, and it can be like hard to know like what to do or whether something's steering. And I cannot stress enough, you can call us. We will talk to you about it. Always document these experiences when you have them in whichever way you feel most comfortable with. I always say, like, if a landlord tells you vocally that something that they won't do something for whatever reason, you can send an email, send a text, just be like, hey, I want to follow up on that. And you know, like any way you can get that documentation, it's going to just really help protect you and make sure that you have that housing choice. Remember, I said I was going to talk more about the disability protected class. And that's because the disability protected class offers the extra right to what's called reasonable accommodations and modifications. So disability under the Fair Housing Act is very broadly defined. And I want to stress that too, because I know that there is a stigma with the word disability. I know that lots of people are very comfortable with the word and like use it in a way that like feels appropriate to their personal needs. I also know that there's a lot of people that need access to accommodations and modifications that won't ask for them because they have assumptions about what it means to fall under that protected class of disability. Renters that fall into that protected class have the right to ask for reasonable modifications or accommodations to the lease. Modifications a little bit more easy to explain. That is a physical change. So for a person, like if they need grab bars in a shower to safely shower, if they need a ramp to go in, go over the 3 stairs to get into the apartment, anything that makes their place more accessible. The other thing I really want to stress at this point is that I've talked to a lot of people that have like made do, you know, like I can't get out of my apartment alone, but like don't worry, my daughter visits a lot and she helps me when she's here. Like that's not safe. Like if you can't enter or exit your apartment or your living situation without assistance, it's a good moment for you to contact us and ask us how you can get a modification that's going to make your unit accessible and safe. You need to be able to like exit if there's an emergency. The hitch with modifications is that the tenant is responsible for the cost of that modification, which is a lot. However, Vermont Center for Independent Living has a grant program. That's another statewide program, really excellent advocates. And like this workshop is a lot, it's recorded, so maybe if you're watching it recorded, you can go back and go over this information. But also you could just call us and we'll go through this piece with you. We do help people apply for reasonable modification grants through VCIL, Vermont Center for Independent Living. So if you need this modification, let's make sure you get in touch with us. We'll connect you to resources so that you can have that modification made. The other hitch, and I don't want to dissuade anyone from doing a modification, but the other hitch is that technically you are responsible for deinstalling that modification when you leave. Usually the modification is value added. So we are happy to work with you to talk to your landlord and let them know, like, hey, like this, actually is a value added. It's going to make it more accessible. You can rent to more people. Like, can we have, modify the lease so that's not something that I have to deinstall? And we can just help you come to an agreement with your landlord. Most cases, landlords are like, that's a boon to them. But the law states, so that's where we're at. The other right that you have as a tenant is right to reasonable accommodations if you have a disability or fall into that disability protected class. And this is a very nuanced space that's also like, offers so much for like people that fall into that protected class in terms of housing stability. So like there's a lot of things that can be challenging as a renter, especially renter that has certain needs or like certain stimuli might be too much. Like for instance, let's say your landlord has a rule that you have to go into their office to deliver your check. And that's the only way your landlord will accept it. You can ask for a reasonable modification, accommodation, a change to a rule, policy, or practice that you can mail your check. The reasonable accommodation part of the Fair Housing Act is a place where there's a lot of creativity. I've heard of Vermont Legal Aid working with people who were facing evictions to get an accommodation, to give them more time, or to give them like some leniency on breaking a rule because of like whatever specific situation that they're in. Parking, that's a big thing that comes up with accommodations. So let's say that you have some mobility challenges and you need a parking spot that's closer to your unit, or you can't find parking spaces and it's making it hard for you to get back into your home. You might ask for accommodation for a parking spot. Reasonable accommodations come up most often when it comes to assistance animals. So assistance animals, distinct from service animals, perhaps including service animals, are often accommodations people ask for that have fall into that disability protected class. And so, sorry, I'm like, is there food in my mouth? That would be really funny. Not as funny for me. Thank you. Okay, assistance animals. There are ADA laws that apply to public spaces around service animals that are much more stringent and specific about what constitutes a service animal and what constitutes a disability that would require a service animal. In the Fair Housing Act, as I've really tried to emphasize, disability is very broadly defined. It is, has a lot of flexibility. In order to verify you have a disability, you just need maybe a therapist, a doctor, even in some cases a family member can sign off and say this person does have this challenge. The key to it is that your accommodation or modification has to be related to your ability to access housing. So it's really got, you have to just make that link clear. So all to say that oftentimes folks have assistance animals that provide kind of an emotional comfort that's really important to accessing their home, and that falls under the protected class of disability. I can't remember if I had a specific slide. So, my thing doesn't want to go back. Only forward. All right, I will remember that. That's okay. The thing I have to tell you is not on a slide. If you need help asking for a reasonable accommodation or modification, we have a whole host of sample letters on the Vermont Tenants website. I'll be showing you where that is as part of this workshop. You can call us and we'll help go through that with you as well. technically under the law, you could make a modification or accommodation request verbally, and they still have to respond in a timely manner. That could be to your maintenance person, that could be to your landlord. It still counts. Of course, we advocate for the written record because it allows you more protection should your landlord not respect your accommodation request. Let's see, but I think there's kind of a lot there. So just to say that we're always here to talk about talk over your specific questions and to go into deeper depth especially around modifications and accommodations, because they're really important tools to accessing housing stability. But best practices for housing providers, which is helpful for tenants to know, respond to requests in a timely manner. It's coming back to me. The other thing I should emphasize about reasonable accommodations and modifications is the term reasonable. So I talked about the ramp for the 3 steps, right? If it needed to be an elevator, probably not a reasonable ask for a landlord to accommodate, to modify an old unit for an elevator. So just to say that there are times when a landlord can say, this is just an undue burden on me. The other thing is that sometimes there's conflicting accommodations. So let's say you have an assistance animal, but your neighbor has some serious respiratory issues and serious allergies to the hair that your assistant animal has, and you're in the same common spaces. Those are things that do come up. And there are solutions that can allow both people to live their lives healthily and stably. And we can talk to you about them. Use consistent terms and conditions in the property. That's another good one for landlords to know, or housing providers. So if you see that your neighbor has a different language in their lease, even if you're not sure why, for me, it's a big red flag. It's like, well, why is that lease inconsistent? Same criteria for all clients. So if your landlord suddenly develops a problem with tattoos, and you're a person of color and there's a person who's white and has tattoos in the community, seems like a big red flag. So all of the standards have to be equally the same. Disparate impact is a whole nother can of worms. So always, if you think that you are having challenges accessing your housing and you're having specific instances with landlords, you should call us so we can talk to you about it. Language ideal for singles in advertisement. That sounds like a problem with the marital status protected class, because it goes both ways. And then the other really important thing is when it comes to making your accommodation or modification request, you do not have to tell your landlord what it is that you need that. You have to make the connection, this assistance animal is important for my ability to live here. You don't have to say, I have anxiety. That's not the landlord, for the landlord to know. And we actually just advise people, be as, say as little as you need to. And we can, that's why I really encourage people to use our pre-written letters, because it's written and then it has a little box. And there's not a lot that you can tell about your personal life in that little box. So it helps you protect yourself from the instinct to kind of share your personal information with your landlord. So I said this so many times, you can call us and talk about all these issues. So we have the Fair Housing number right on the top of the screen. But what I always say is that if you call the Vermont Tenants hotline, they will refer you to us because they are just down the hall from us. We all work together in the same office. And I stress that because already I'm dumping so much information on you. And in Vermont, we have so many housing organizations that I think it's too much to expect you to know in advance if it's a housing discrimination problem or if it's maybe landlord-tenant law. So just you can call us always. If you are not sure if it's discrimination or if it's a fair housing question, you can call Vermont Tenants and they will make sure you get to the right spot. And then as I mentioned, we are not lawyers, so that means we don't enforce the law. So should you decide that you want to file a complaint against your landlord, we will connect you to either Vermont Legal Aid or Vermont Human Rights Commissions, both statewide organizations that provide lawyers for folks that are in that precarious spot of experiencing housing discrimination. That's a process we'll talk to you about. You do have up to 1 year from like experiencing that event to file the complaint, which I also emphasize because usually when we're like in that situation where we're finding housing and then we have housing discrimination, our first instinct is like, we need housing now. So it's okay to go secure that housing and then give us a call and we can start that process with you. I'm not gonna go through that. All right, tenants' rights and responsibilities. All right. First and foremost, a lease is a contract. That's an agreement with you and your landlord, which means it goes both ways. Under the lease, you have responsibilities and you have rights. Under the lease, your landlord has responsibilities and also has rights. So you both are agreeing to that contract when you sign that lease, so it's really important to know what's in it. Something that we do for people, if you're unsure about clause or if you want someone to go over that lease with you, you can call us on our hotline. So like, that's gonna be the punchline of this workshop. Got questions? Call us on our hotline. And we'll make that number really accessible for you all. You can also Google Vermont Tenant Hotline and it will come up. I covered that, both landlords and tenants. All right, starting with security deposits. So tenants have a right to refundable security deposits. What that means is that if you do not receive your security deposit back, you are owed an itemized expense of what that security deposit went to. There's no such thing as a security deposit that is not refundable. That is against the landlord-tenant law here in Vermont. So the best way for you to get that security deposit back is to document the unit before you move in. And I say before you even move that first box in. Most of us have cell phones at this point. If not, borrow a friend. They got cameras that are sufficient. You can go around and take pictures, not just of like things that look like they might be dings or scuffs on the floor, but like inside your refrigerator, inside your shower, underneath the cabinets. Like be as thorough as you can. There's no amount of too thorough. That's gonna be really important for when you move out so that you can show like, this is how it looked when I moved in. It's your responsibility as a tenant to keep the place tidy and in good repair. No, it's the landlord's responsibility to keep it in good repair. We will be talking about cleanliness and repairs as part of this workshop. And then of course, after moving out, you're gonna document again because that's how you can compare your before and afters. Oh man, I wish I could go back. The one thing I want to, like, there's a couple things with security deposits. We'll be talking, if your landlord doesn't return your security deposit, you have the right to go to small claims court. So when we go through the kind of move out, the way this workshop works, it's like we start move in and we go through the thing and then we go to the move out. And so then I'll talk a little bit more about like what to do if you don't get that security deposit back. Tenants have a right to privacy in their home. So what that means is a landlord might enter anytime if you agree. So landlord pops by, it's like, hey, how you doing? Can I come in for a quick sec? And you're like, sure. So then the landlord can enter. But you don't have to say sure if they just pop by because the landlord has to give you 48 hours of notice before entering. And 48 hours between the hours of 9 a.m. and 9 p.m. So the landlord can't be like, I have to come by tomorrow at 7 before work. I mean, they can say, I would like to, and you can say yes. But you can also say, actually, I would like 48 hours notice and between the hours of 9 a.m. and 9 p.m. And the landlord can't just drop by to check things out. So there's really specific reasons why the landlord would have to enter your unit to inspect. So if there is something that, like, you know, if there's an annual inspection, if there's something that might be leaking, there's something that might be broken, but they can't be just like checking in, you know, like, hey, I just want to see how it's going. That's not, that doesn't fall under the category of inspection. To make repairs, of course, if there's something broken, the landlord's responsibility is to fix it. So if they are allowed within the 48 hours notice, between the hours of 9 and 9, to give you that notice and make the repairs. And to show the unit to other folks, which is something that comes up like a lot in like big moments of turnover. Maybe not so much here. I guess I don't know what the landscape is like, but sometimes like those showing the unit can be quite exhaustive for people, and so there's some ways to kind of navigate that. If there's an emergency, like a fire or flood, the landlord can enter without 48 hours notice. Like, kind of makes sense. And it's important to note we're going to be talking about notice periods for leases, which are different than forms of notice for entry. So whereas leases, there's a really specific way that a landlord has to notice for you if they're ending your lease or changing your rent. With landlord access, it can be by text, by phone, or hand delivered. This comes up a lot in some of the communities I work with, because for some people, you know, like phone might be really hard for them to access because of their needs or something about the way they move through the world. Maybe they change the numbers a lot because of something relating to their needs under their protected class of disability. I've also heard from folks that like, you know, like something about the hand-delivered note just really like can be destabilizing for their mental health or their well-being. I would advise them to ask for a reasonable accommodation. And I have written many reasonable accommodations in conjunction with tenants to help them figure out how they can, what form of communication is going to work for them in terms so that they actually get that notice that their landlord's going to enter. Because there's nothing worse than like being like in a vulnerable position and having someone just come in your house. And so if they're actually following those 48 hours notice periods, we want to make sure that it's in a way that you can get it, receive it. So call us if you want to go over that with us. If your landlord accesses without your following the notice periods, your first mode of resort, you can give them a landlord access letter. I know it seems kind of like a menial thing, but there's something about this that actually has worked a lot for people, because what it's showing is that you are showing the landlord like, hey, in case you forgot about this law, here's the law, and I know it. So please, let's both respect this law. And it's, you know, just reminding the landlord, like, this is the contract we agree. And sometimes just knowing that is enough for the landlord to, you know, stop entering without the proper notice. Of course, always when it comes to like your rights being violated, we have the law that we can go to. It's a process. That's just how the law works. It's not, I wish there was an easier answer. But in the meantime, the landlord access can be a really good method for protecting your rights to privacy. Let's see, not following rules versus following rules. I'll just go through the top two and people can read the rest on the video. So, not following rules. A landlord gives notice for a repair starting at 8 a.m. That's not within the hours of 9 to 9. Following the rules, if a landlord has given proper notice, they may enter the unit even if the renter is not home. So that's something that is a common misconception where people are like, well, it wasn't there. Well, if they gave you notice, even if you didn't receive it, in the way that would have worked for you, they are legally allowed to enter. And that's why I say if that becomes a problem, you should talk to us. Health concerns, another place where we can exercise maybe a reasonable accommodation. So, you know, it's COVID, COVID times. We're all aware of like respiratory concerns. We're all aware of sometimes it's not safe for you to be in the same room as someone from coming outside of your home. So we can always work with you to ask for that reasonable accommodation so that you can like be giving notice in a way that allows you to have space so that you're not there when that happens. Or if it's something like they're showing the unit, you can ask for a video. That's became really common during COVID. Okay. All right. Part of your contract, your lease, you're both agreeing that you, the tenant, have the right to safe and decent housing, that the landlord is providing for you. That's the service that they're providing, that they've signed up to provide it. And a right to report free from retaliation. So the landlord's always responsible for making repairs. There's no like signing away that responsibility in a lease. So if you rented a unit with a working refrigerator and the landlord puts in the lease, I will not replace that refrigerator if it breaks. That's just against the law, and it's not enforceable. The landlord, like if you've signed up for a unit with those things in it, those are the things you've signed up for. That's the contract. It's not uncommon for people to hear that their landlord's not making repairs. And there's different levels of repairs. There's nuisance repairs, and then there's like major health concerns. So we're starting with the nuisance, the things that like are annoying, but are not gonna ultimately you know, lead to like a major health concern or you know, challenge your ability to live there. So let's say you've let your landlord know like the cabinet in the kitchen just fell off. The landlord maybe doesn't answer right away. So we always say notify in writing. All communications with your landlord, as much as possible, do it in writing. If it's like certified mail is like the most recognized safe form, but I gotta say there's nothing wrong with sending an email, in my opinion, because it is a written document. If you are starting to push up against the law, do certified mail because it's like, you know, unquestionable. You know, US mail kind of in general is helpful. You can keep a log, so you like always keep a copy of your communications for yourself. You know, maybe write down like time and date that you're sending things. Like put the date on those, like if you're using the mail, make sure you put the date like in that letter that you're sending to them, that you're also keeping a copy for yourself. You can wait 30 days. And if the repair doesn't happen, first and foremost, you should call us because we might be able to help connect you to a town health officer that can help advocate for your needs. But if it's a small thing and it continues to not be addressed, you do have the right to repair and deduct. The thing about repair and deduct, it's a really specific formula. So anytime you don't give your full rent to your landlord, you are jeopardizing your lease, you're just jeopardizing your agreement. So that's why we just like stress the repair and deduct format is on our website, like really explicit. Even so, just give us a call because we really want to make sure that you are following that to a T. Yeah.
Don't mean to take away from your presentation, but renting portals in regards to like sort of like communication with the landlord, how does that play out usually?
What's a renting portal?
Like the online version that you send messages through?
Yeah, so
like the portable apps.
Yeah, I have a portal that I have access to my lease and communications with the renting office, but also there is maintenance requests.
Oh, through the portal.
Through this online website app.
Yeah. Well, I would say that if it's not, like, it's hard for me to stand here and be like, certified mail is the way to do it. It's the law, it's what I was taught. I'm really reliant personally on more accessible forms of documentation. So for instance, if you're using this portal and they're not responding, I would take screenshots. Like at that point, if they keep not responding, you can send certified mail or just US mail or even an email. It's all documentation. So really what it comes down to is like what's gonna happen if you have to take them to small claims court to get like the problem remedied. And in the end, like, you know, documentation, like having like, at this time I asked for this thing, at this time I asked for this thing again, and then, you know, 10 months later, here it, like, that's kind of undeniable. So like in the end, like, it's like the law has like hard and fast things. They're like, oh, this works every time, certified mail. Nowadays, there's a lot of, you know, documentation that is digital. So all to say that like I'm not a lawyer. I've been told to say certified mail. I will also just say, if you've got documentation, like you're doing the right thing. And you can always call us. So I would say like if they're not responding to that like maintenance portal thing, then you should just call us right away, because then that could be something like we can remedy or advocate. Maybe we've already gotten calls like that. It's also like another form of documentation because we have a log of all of our callers. So if you came back to us and say, hey, I need some proof that I called you on X date, that's something that we have in a portal that we can pull up for you. Yeah, and that's, the thing is that like if we're talking about like, you know, that knob coming off your drawer, or like the paint's peeling and it's not lead paint, of course, because if it's lead paint, that's a huge problem. But like those are like things that like they are uncomfortable. And like, should you get to the point that you need to do a repair and deduct, we can walk through that with you so that you don't live with that discomfort. If it's a major health violation, we're not waiting 30 days. Major health code violations include plumbing. So if you don't have water, if your septic or your sewage is coming up into your unit, these are major code violations and are emergencies. So we would say call your town health officer right away. Plumbing structural issues, so your house needs to keep the outside out, inside in. So if you've got like critters coming in from the outside, if your heat is not able to like stay because it's like not properly insulated, if the rain's coming inside, those are major code violations. They need to be addressed right away. Fire safety, so that means if you don't have a way to escape your house in case of fire and your front door is blocked, that's a major code violation. And then pests, that's a really big one too. Sometimes people like, you know, it's another place where there can be stigma. Pests happen all the time. You know, bed bugs love furniture that's been outside getting wet and then brought inside. So if you're thrifty, just something to think about. Inside furniture belongs inside. If it's outside, it's like starting to be an environment that could bring something inside. But as soon as you got something like pests, it's really important to address right away. The thing about pests is if it's traced back to you, your landlord can put the cost on you. That said, roaches and bed bugs, if you got them, your neighbors almost definitely got them, and like once it's in more than one unit, or if it's in the common spaces, they can't pin it on you. So you just gotta say something right away, and pests must be addressed by an exterminator, one whose job it is to exterminate, that has the proper certifications, whatever those are. It can't be the landlord going to CVS and buying like rodent killing stuff. Like same as plumbing. Landlord can't be like, hey, sometimes I like to fix the plumbing. Are you a certified plumber? If not, then no, you cannot be the person to fix the plumbing. All of these things, we can talk to you about the hotline and make sure you get to the appropriate resource. The process, you notify in writing. So again, it's the laws like certified mail or at least US mail. And then, you know, like the closer you get to certified mail, the closer you are to like covering all the possibilities. I do understand too that for some people that can be a kind of a barrier. So document, document, document. Keep all copies of your documentations. And then you would call your town health officer. That's something you can Google usually. Like everyone's got their different town health officer. You'll probably find it. You can also call us. Incidentally, we do a lot of calling of town health officers. And by we, I mean our hotline advocates. I'm not the one doing that work, but I know that they're doing it all the time. All the time. So they might even know your town health officer, which can be really helpful to have like an outside advocate that can contact your town health officer or let you know who that is. I will say the town health officer system is very flawed. We tried to get it addressed in the legislature last year. They did make some changes and we're seeing how it works. And it's flawed because a lot of these town health officers are you know, not paid staff. There might not be like extensive training that they're going through. And in small towns, you might know your town health officer and they might have bias against you. That said, town health officers also have to follow fair housing law. So I'll just say that we are here to like help like walk through this process with you. Yep, so tenants have the right to report, free from retaliation. Reporting major code violations, as I said, complaining to the landlord for a violation of tenant landlord law, organizing or becoming a member of a tenants union or a similar group. They're all protected under landlord-tenant law. If your landlord does anything within 90 days of like anything retaliatory, like sends you like eviction notice or like hikes up your rent or you know, a whole spectrum of stuff, it's automatically considered, the assumption is it's retaliation. I shouldn't say automatically because again, I'm not a lawyer, so I can't say the law will do anything in particular, but this is just to say that we have pretty strong protections in terms of retaliation. And again, you know, not all landlords know that. So some landlords do, and they'll do something on day 91. Still can be traced back to retaliation. It's just a little bit, it asks a little bit more work of you to prove. Tenants have the right to proper actual notice. So when I was talking about notice periods for entry, it could be phone call, text, a sticky note on the door. If they're gonna increase your rent, it's at least 60 days. Before termination of tenancy, typically 30 days, but can be more. That's a really important asterisk. So things that can change your notice periods. Let's say if you've lived a place for a really long time, your rights increase. Notice periods can be different if you have like a month-to-month lease or like a lease that's week-to-week. There's a lot of like unique leases and live-in situations that people have. So we just say like when it comes to notice periods, you can please just call us if you're unsure. But at the very least, rent increase is 60 days. And it should be noted, your landlord can't increase your rent in the middle of your lease. So that's 60 days of notice. If you have a year-long lease, like it's 60 days before your lease starts up. That's when the notice period is. One thing I should say is that lots of people sign a year-long lease and they don't hear from their landlord the next year, and they're like, cool, I'm renting another year. What's actually happened is that your year-long lease is now month-to-month. So that's a really common way that people end up on month-to-month leases. So if you're on a month-to-month lease, 60 days notice before rent increase is like a much different thing right? It just doesn't offer you as much protections. Of course, there are plenty of people that, you know, the month-to-month is offers more security in terms of being able to move. Because if you break your lease, like, you are also, you know, contractually obligated and could face some fines. But I would say that in this housing market, it's really important to make sure that you have as much protections and stability as you can. Yeah, obviously always call us if unsure. But so the actual notice is by mail. So it can't be a sticky note on the door. They can hand you an envelope. But it can't be a phone call or a text message. That does not count as notice. It can't be word of mouth. The maintenance person can't tell you that the landlord's gonna do that. Like, none of those things count as notice. In Vermont, 70% of evictions are due to non-payment of rent. That's really important to note. Evictions do happen. They can happen in the winter. I feel like there's like a myth, maybe like, oh, but not in the winter. Nope, they do happen in the winter too. 70% is due to non-payment of rent. So we say, if you're not gonna, and non-payment of rent on time. In Vermont, we don't have a grace period. There's no such thing. That's like maybe another kind of myth that we rely on. And sometimes landlords will verbally say like, hey, if it comes like 5 days after, I'm chill. Unless your lease says, if it comes 5 days after, I'm chill, that is not a real thing to believe. In Vermont, landlord-tenant law says the rent is due on the day it says in the lease. For some people, that might be the 15th, you know, and you might not know, right? Or you might start your lease on the 15th, so you assume it's the 15th, but the lease says the 1st. So that's another place where it's important to check your lease and make sure the rent is there, because as soon as the rent is late, the landlord can start this process. So that said, if your rent is going to be late, just let the landlord know, like, hey, it's coming. It's like a couple days late, or I'm having problems like paying my rent. Can I give you X amount now and X amount like halfway through? It's better to have that conversation than to like stick your head in the sand and hope that they don't notice, because they might just start the eviction process. So the eviction process, it starts with a written 14-day of notice of termination. So that's a notice that you get in the mail. It says, we're going to terminate your lease. The thing I want to also know about the process is it's pretty long. Like, who knows how long? It's really dependent on the courts. So it could be like months. It could be more months. It could. But just to say, it doesn't happen overnight. So oftentimes people get to step one and they're like, they just move out because it seems scary and their landlord sounds serious. Also, step one can't be, landlord tells you I'm evicting you. That's not step one. Step one is a written notice in the mail. And that's 14 days from the moment where you broke the lease. Step two is summons and complaint. So as soon as you get to step one, you should be contacting us and Vermont Legal Aid. If you contact us, we'll just connect you also to Vermont Legal Aid. A lawyer is really important for this process. By the time you get step two, definitely have a lawyer, because the summons and complaint has to be filed as an answer in court, and that's a specific way. So if you're like, I got this, like, I don't need a lawyer, I'll do this, I'll Google it, you could really be jeopardizing your tenancy. So it's important to make sure that you have adequate representation. Vermont Legal Aid's a great resource. There's other great resources. We can always help you connect to them. And then the next step is there's a court hearing, and then maybe there's a writ of possession. If at that point, if the court finds that you you should be evicted, the landlord goes through with eviction, then there might be a writ of possession. and that's served by a sheriff. And if your stuff is in the unit by the time you get to the 14 days after the writ of possession, so writ of possession served by sheriff, if 14 days later your stuff is still in the unit, the only person that can remove your stuff is also the sheriff. So at no point in the eviction process is the landlord legally allowed to change your locks, take your stuff out, turn off your utilities, heckle you, throw eggs at you. None of this. This is the way. And it's really because we hear all the time people like, oh, my landlord changed my locks, threw out my stuff. Like, that's not legal. That, again, cannot stress enough, like really early on, contact us. Because if we can help you pay the last of your rent, this can go away and you can stay there. Yeah, just really important to know, like, your landlord should not be changing your locks. It's just against the law. The other thing that comes up a lot, this is a really complicated subject, peaceful enjoyment. So part of your lease is that you have the right for peaceful enjoyment of your home. And also the responsibility to not disturb others' tenants' peaceful enjoyment of the home. That also includes your guests. So like, if there are quiet hours in your building, or if there's city, town, like sometimes there's city and town ordinances around sound, make sure you know what those are. If you're having guests, make sure they know what those are. Because if you have guests that if you or your guests are disrupting someone else's peaceful enjoyment, you're risking your tenancy because you're not following your lease. So noise curfew hours is really important to know. Harassment in common areas, that's not allowing other people to peaceful enjoyment. If you're being harassed or if you're experiencing loud noises, it's complicated, yes, but also it's still your right for peaceful enjoyment, and you can call us and we can help advocate for you. Smoking, all HUD subsidized properties are non-smoking. So remember that huge chart I showed you of all the different funding sources? Oftentimes HUD is a funder, and that's hard. If HUD is funding your property, there's a hard no smoking rule on the property limits. And we, of course, have heard lots of people struggling with that rule, and we've had lots of persons struggling with people not following that rule. So smoking gets really complicated. Guests, if you are in a subsidized property, make sure you know what your, for instance, if you have a housing choice voucher or a Section 8 voucher, as otherwise known, there are really specific amounts of time that you're allowed to have a guest. Certain subsidized properties will have different time limits. So it's important if you have a subsidy to know what those are. For instance, people like using a Section 8 or a housing choice voucher, there's a set amount of days and it's cumulative. So it's not like you can't stay more than this days. It's like you can have a guest X amount of days throughout the year. And that's something that we hear a lot of folks having challenges with, especially people with more dynamic families that like might be changing, or you know, so like someone in their family like needs housing quite suddenly. It's always important to have those conversations with your landlord, and it's always important to make sure you know what the rules are with your subsidy. Peaceful enjoyment response. We always say you can first start by talking to your neighbor. Probably, you know, it's gonna work out better than your landlord talking to your neighbor, which like automatically might create conflict. And sometimes neighbors just don't know. Of course, we know that sometimes they do know, and they don't like that. If your neighbor continues to have a noise problem, you can talk to your landlord. Again, we stress it's really complicated. Some people have needs that you know, might be hard to regulate. And so we really ask people to you know, use empathy when they can, use compassion when they can. If you have a disability that really requires a certain amount of protection from noise, we can talk about accommodations and modifications for you. So again, lots of creative solutions in there, and you know, obviously feel free to call us to talk about that. All right, we're doing like the quick summaries now because we're towards the end. Tenant responsibilities, pay rent on time. That's the one day in the month. Communicate early and often with your landlord. So we were talking about repairs. It is actually the tenant's job to let landlords know that repair needs to be made. So some tenants are like, I'm an easy tenant, like this doesn't bother me. Like this drip of water coming beneath my sink is like hardly noticeable, it's just a noise I hear sometimes at night. Well, that drip of water can turn into water damage, which can damage the cupboard, which could be out of your pocket. So it's another place where it's like you're not doing anyone a favor by not reporting repair. And even if your landlord seems like frustrated by it, it's actually in both people's best interest that those repairs are reported. And if you know, you report the repair and the landlord doesn't fix it, then it's definitely on them. Or them, I shouldn't say. I don't know why I always assume they're them. Communicate early and often with your landlord. That's, you know, if your rent's not gonna be there, if you're gonna have someone staying with you, if there's a repair. Follow the terms of your lease. So make sure you understand what those terms are. Subletting and guests. Lots of leases have explicit rules around them. Even if they don't, you should have a conversation with your landlord if someone's gonna stay with you for any amount of time. I've done that before. I've had family move in with me. We wrote a sublease for a specific amount of time. And it was probably better than if my landlord stopped by and found my sister in my apartment. No smoking, make sure you know that. Pets, if you think you're gonna get a pet and you move into a lease that says no pets, you know, might not be a good fit. Have a conversation with your landlord before you get a pet. If your landlord says yes, make sure they amend the lease. That's another thing, like verbal confirmation. It's just better to have it written. It just always is, because you know, they might say next month, like, I didn't say that. And it could you know, put you in a bad spot. It's the tenant's responsibility to keep the place clean, take out trash, recycling, compost here in Vermont, and request those repairs. So make sure you know when you're like, if there's trash pickup, make sure you know what that day is. Make sure you know what the expectation is if you're taking your own trash to the dump. Give proper notice when you move out. So just as landlords owe you proper notice, you owe them proper notice. So make sure that if you know that you're not going to re-sign the lease, you let them know at least the 30 days, sometimes as much as 60 days. Obviously, it's always safer to go a little bit more if you know. And you can call us to ask what your responsibilities are there if you're confused or you need some guidance. Communicate, communicate, communicate. We have so many types of sample letters on our website. We'll make sure that the sample letter is like included in our outreach with this. In writing, obviously, keep your own records, keep all documents. And the one thing that I thought was going to come back up, security deposits. If your landlord does not return your security deposit within 14 days of you letting your landlord know that you moved out, which you have to let them know, right? You have to give them notice. They have 14 days. You let your landlord know, I am fully moved out. Then from that moment, they have 14 days to get you back your full security deposit or your itemized expenses of what they used it for. They can't use it for reasonable wear and tear. They can't use it if they always, like, let's say they always clean the carpets between tenants. That's just what they do every time. Then they can't take that from your security deposit. It has to be like things that are not part of their everyday practice of landlords. It has to be damage that you caused. If you broke the like toilet paper thing and didn't let them know, that can come from your security deposit. But it can't be like, oh, I always hire this team of people between tenants. That is not a valid expense. If you don't get that within the 14 days and you take them to small claims court, it's not uncommon that landlords find that that courts and housing boards of review find that landlords unreasonably withheld that security deposit, in which case they might actually reward you up to double. So it's just to say that that security deposit is important. Make sure you follow up on that the way that you need it. Whew, and that's it.